Hello friends, Mandar here. I'm back with another video. Today I'm going to cover some important questions regarding I140, I485, regarding the downgrade petitions, what happens with them, and when they are going to come into effect, impacting the priority dates for EB2, EB3, and some other questions. So you never know which question is going to be relevant to you. So watch this video until the end and let's get started. If you are here for the first time, welcome. My name is Mandar and I make immigration related videos for US and Canada. I'm not an immigration lawyer, so anything that I say on this video or on my channel is for information purpose only. And for your specific immigration needs, you should hire a competent immigration lawyer. Now before we get into the topic, I wanted to ask you a question. Do you prefer me sitting here and talking to you throughout my content and giving you the content right in my own words without changing any background or without giving any other video rolls or B rolls or A rolls kind of thing, or drone footages, giving you the information not in my voice but in some other voice? Or do you prefer me sitting here and talking to you, giving you the information in my own voice directly? Put down in the comment section below and I would like to see what your thoughts are. So with that said, I just picked some important questions from the comment section and from the emails, and I thought I would make a special video just to cover some of them. So don't miss any of these questions because any of these could be relevant to you. So let's get started. And before we get started, if you are here from Canada and if you are interested in Canadian immigration, I'm also going to make a video in the next 2 days regarding the express entry draws and several different draws from several different provinces. There has been some action on the Canadian immigration side as well, which I will be covering in my next video. So stay tuned to my video, and if you haven't already subscribed, do subscribe. Now the first question is, and this is the question that I got from quite a few people, that once you receive a green card, what are your obligations? What is next? Now check out my video that I made, and it's also on my channel intro page. What happens next, or what to do next once you get your green card. Now some of the things that you might want to remember is when you get your green card, your family could be in several different age categories. So you might be in your 30s or 40s as also your spouse, but your children might be in a certain age group where they may have some obligations. For example, if the child is between 18 to 26 years old, they are required to register in special services, which is register in the US Army or US Navy. So check out that, and when you get your green card, you will also get an information brochure that will outline what are the obligations for the newly permanent resident applicant. So that is one of the key things that you need to remember. In terms of what you can do in terms of job change, you don't have to wait to change your job. Once you get your green card, there is no law stating that you have to remain with your current employer that sponsored your green card. You could go and work for any other employer. There is no law saying that you have to wait with your current employer for a certain duration. The next thing in the process is your 10-year green card or your citizenship application, and I don't think they will be looking at when did you change your job. Of course they will be doing your background check and things like that, but you will not have any obligation to remain with the current employer or to change your job after you get your green card. Now the second question is, and this has been a question that I have been getting for a long time, and I have been missing answering this because I did not have the right information. So basically the question says, if you are a family and you get your green card EAD, do your kids need the green card EAD as well? Now here is the tricky part. The kids actually are not authorized to work, but USCIS do issue the EADs for kids or children over 16 years of age, but I found it very hard to find it information. So if any of you have any information on this or can point to a website which tells you about this rule, please let me know. But as per my understanding, children over 16 years of age will get their own EAD card. Now most of the information that I give you here is common public knowledge. It's on the websites of the USCIS or any other websites. So there is nothing that I make it up. When I was going through the process, there was no such video that gave me some detailed information. I had to pay hundreds of dollars to lawyers to get the same information that I'm giving you now. So now the next question is, has the final action date ever retrogressed? So the question is, we have two charts, which is filing dates chart and final action date chart. Now I have made a special video on telling the difference between these two charts. Now the question is, do final action dates ever retrogress? The answer is yes, and they have been retrogressed a lot over the last few years. The classic example is EB1. EB1 used to be current. In the recent few years, it retrogressed back to like almost 2015, and now with the flood of visa numbers available, now they are back to current. So you have seen the retrogression and also the progression of the EB1 dates. The same thing has happened in EB2 and EB3. Now why does this happen? And Charlie also mentioned this or explained this. If the Department of State moves the dates very aggressively, thinking that they would create a demand, and in doing so, if they create a much higher demand than what they anticipated, then what happens is now you have more people eligible or eligible to get a green card or documentarily complete, but not enough visa numbers available. In that case, that is when they have to retrogress the dates to curb the demand. So basically they have enough demand to fill the number of visa numbers, and now they have to retrogress so that they can hold that date in order to get some more visa numbers to fulfill the demand that already has been created with the progression of date. I hope that makes sense. Now here is an interesting question. There is a category in EB, employment based green card, where you can self petition, and there are a lot of categories, but typically I am talking about EB1A and EB2NIW, which is EB2 National Interest Waiver. In this particular category, you do not need a sponsorship from an employer, but you do need to fulfill certain conditions. Now you need to be able to prove that you have substantial merit that is in the national interest. And once you get a green card, you are going to use that knowledge in the national interest, in the area of work which will be in the national interest. So in that case, what happens is, if your file is properly filed by your lawyer, then you do not need to go through the labor certification. You can directly apply for I-140 and then 485, and also there is no sponsorship required. So this is a unique category. Now the question is, if you are in EB2 NIW and your date is still not current, but if your corresponding EB3 date is current, can you downgrade the petition? Now remember, downgrade from EB2 to EB3 is nothing but applying for a brand new EB3 I-140 based on your same perm application. Now here is the problem. Because your EB2 NIW application did not require a labor certification, you do not have that for your downgrade petition to EB3. Besides, the EB3 application will require you an employer sponsorship. So there are two things: you don't have a labor certification and you don't have an employer. So it's not really a downgrade. So if you are an EB2 NIW and you are trying to downgrade, it's different, because now you need an employer sponsorship and you also need to go back and do your labor certification. So that is something to consider. A normal EB2 would have an employer sponsorship and it would also have been gone through a labor certification. Now another question, and this was covered by Charlie's interview as well, but I will try to explain it again. Now talking about downgrades, and this was covered in Charlie's interview as well, but I wanted to kind of explain it again. A lot of people have been downgrading their petitions from EB2 to EB3 just to take advantage of further progression of priority dates so that you can apply for 485. Now that is a valid thing, and it has been always been the case that you were able to downgrade and upgrade from EB2 to EB3 or EB3 to EB2. That is always possible. The thing here is what happens, what impact is it having on the visa bulletin? That is yet to be seen. What has happened is there has been a lot of downgrades that have happened since last year, since last October. EB3 dates have been consistently more advanced than EB2 dates. now creating a flood of applications that are now processing their EB3 petitions as well. Now remember, their EB2 petition is still in progress, so it's not like you are cancelling your EB2 petition. It is still in the process, it's still in the 140, and it might still be going into 485. Now the only time that the visa number gets assigned, as you know, is when your case is documentarily complete. Now whether your downgraded petition gets counted depends on how far along in the process that petition is. If it is still behind your EB2 petition, it is likely that your application has been counted for the demand number from EB2 category and not yet for the EB3 category. So now when the time comes when your EB3 file progresses enough to be able to be counted against the demand for that particular category, then your EB2 number will drop and EB3 number will increase, or you'll get a visa number assigned from the EB3 quota instead of EB2 quota, and that's when we'll start to see all these changes reflecting in the visa bulletin. So I'm suspecting in the next few months, maybe after October, EB2 will start progressing much faster and EB3 might slow down, because that's when the impact of these downgrade petitions will start showing up in the visa bulletin. Now another common question is, can a petitioner withdraw an I140? Yes, they can. If the visa, if you have an I140 approved by an employer, and if you quit the job within the next few days, the employer has an option to withdraw your I140 petition. And sometimes I have seen they do it as well. Most of them don't do it because it costs them money to even withdraw the petition, but some actually do it. Now here is the trick. If it is beyond 180 days since the date of approval, then even if the employer applies for your withdrawal of I140, USCIS will still keep your I140 valid, and you can take that priority number elsewhere. Now if you don't if you leave the job immediately and if the employer withdraws it within 180 days, there could be a chance that the petition might not be held valid for the processing of I-485, because for the processing of I-485 you should have a valid I-140 approved I-140 for the priority date to be locked in. So hope that makes sense. If you have any further questions on this particular point, let me know and I can elaborate it even more further. But it's as good as if once 180 days have passed, the I-140 stays with you forever and you can file. Even if the employer applies for its withdrawal, it will have no effect on your approved I-140. Now there is another trick question, whether I should downgrade or stay on EB2. Now it depends on what your priority date is. If your EB2 priority date is close or within few months of getting current, I would suggest stay on EB2. Why waste money and time in downgrading your petition? It's just a matter of few months, but if you are worried about those few months and if you want it now, then you can consider downgrading your petition. And then the last question I'm going to cover is, what is the validity of the green card once you receive it? Now here is the differentiation. The green card status, the permanent residency status, is for you permanently. Now the card that you get has a validity of 10 years. If you get a permanent green card, that still has a validity of 10 years, which is similar to your passport. When you get your passport, you get a validity of 5 years here in the US, or if you have it in India or somewhere else, it may have the validity of 10 years, but still it has a validity. But it is a travel document. Even if you don't have your green card, if your green card expires, you still maintain your status because you are still a permanent resident. You just don't have the proof to show it. So you should always carry your green card after you get it, and you should always have a valid green card if it's expired. Now after its validity or before its validity expires, which is a long period like 10 years, you have two options: either to extend it one more time or to go for your naturalization. And here's another thing: there are certain categories of green cards where they grant you a conditional green card, which is offered for 2 years only. So before the 2 years end, you have to drop the conditions. You have to prove that you have fulfilled all your conditions so that they give you a permanent green card. So that is the difference between the permanent green card and a conditional green card. So that's all I wanted to cover in this video. If you like the content of this video, please hit the like button and consider subscribing to my channel, and I will see you in the next one.